Today, we're going to talk about a huge moment in India's history, a real battle over a question that sounds simple but is actually profound. Can a government change the very soul of its own constitution? It's a story that led to a totally unique judicial idea, one designed to protect a nation's most fundamental principles. So let's just kick things off with that massive question, because it really gets to the heart of our story today. Can an elected government, a parliament with the power to change the constitution, alter it so much that it becomes something completely different? Can they rewrite the most basic rules of the game?
And listen, this wasn't just some academic thought experiment. For decades in India, this exact question fueled a massive constitutional tug-of-war between the elected parliament and the Supreme Court. It was a high-stakes showdown to figure out who really has the final say.
All right, so where did this whole clash even begin? To get that, we need to go back and see why Parliament felt it had, nearly unlimited power to change the Constitution in the first place.
Well, the answer is found right here in Article 368 of the Indian Constitution. And on the surface, it looks pretty straightforward, right? It says Parliament has the power to add, change, or even repeal any provision. It basically looked like a constitutional blank check. But this immense power immediately slammed into a real-world problem. See, after independence, India desperately needed major reforms, especially when it came to redistributing land to tackle inequality. The trouble was, these new laws often bumped up against a citizen's fundamental right to property. So to shield these crucial reforms from being challenged and struck down in court, Parliament created a kind of constitutional safe house, the Ninth Schedule. Any law you put in there was basically untouchable by the courts. And you can probably guess what happened next. This set the stage for a direct showdown. Parliament would pass a law, the courts might strike it down, and Parliament would push right back. So let's take a look at how this tug-of-war really played out. And wow, you can really see the back and forth here. In 1951, it seemed like Parliament won round one. The Supreme Court said, yep, you can amend fundamental rights. But then fast forward to 1967 in the Golok Nath case, and the court slams on the brakes, completely reversing its decision. It declared that fundamental rights were sacred, transcendental, and totally beyond Parliament's reach. So what does Parliament do? It retaliates. In 1971, it passes a whole new amendment to grab that power right back. The conflict was at a boiling point. Okay, so something had to give, right? This escalating fight set the stage for what is arguably the most important constitutional case in India's entire history, a case that would offer up a revolutionary and pretty controversial solution. Let's just pause on this year for a second. 1973. The largest bench in the Supreme Court's history, 13 judges, comes together to hear this case of Ananda Bharti. Their mission? To finally, once and for all, settle this question of ultimate power. And the solution they came up with? Well, it was brilliant. It's called the Basic Structure Doctrine. It was this masterful compromise. The court said, okay, Parliament, you have the power to amend the Constitution. However, and this is a huge however, they said you can't use that power to destroy its basic structure. The best way to think about it is like this. You can renovate your house, change the walls, paint it, whatever you want, but you can't demolish the foundation. The legendary lawyer who argued this case, Nani Palkhivala, just nailed the whole idea with this one line. His point was so simple, but so profound. Parliament gets its power from the Constitution, which means it can never, ever place itself above the Constitution. So you're probably asking, what is this basic structure? Well, here's the clever part. The court never gave a complete final list, and that was on purpose. It allows the idea to grow and evolve. But over the years, they've pointed to things like the supremacy of the Constitution itself, the separation of powers between the branches of government, federalism, secularism. These are the non-negotiables. These are the foundations you just can't touch. But solving one big problem often creates a new one. Remember that constitutional safe house, the Ninth Schedule? What was going to happen to all the laws that were already put inside it for protection before this big 1973 ruling? Yeah, that was the million-dollar question. Were all those important reform laws now suddenly at risk of being challenged in court? Could they be struck down based on a doctrine that didn't even exist when they were passed? It created a ton of legal uncertainty. The Supreme Court finally gave an answer in a 1981 case called Waman. And to create some stability and stop the chaos, it did something really simple. It just drew a very clear line in the sand. So, how'd they do it? They used a legal tool that sounds complicated but is actually ingenious. It's called prospective overruling. They set a hard cutoff date, April 24, 1973, the exact day the Basic Structure Doctrine was born. The deal was, any law put in the Ninth Schedule before that date, it's safe, it's grandfathered in. But any law added after that date can absolutely be challenged in court if it messes with the basic structure. The old rules are done. From this day forward, the new rules apply. So that really cemented the doctrine's place as the ultimate check on power in India. But, and this is important, it's not without its critics. So let's look at its legacy. Is it a guardian of democracy, or is it a case of judicial overreach? On the one hand, its importance is just massive. People see it as this crucial shield that protects citizens' rights and stops any single government from completely dismantling the democratic system. It's a key check and balance. But on the other hand, critics say it's way too vague. Since basic structure isn't written down in a neat little list, they argue it gives unelected judges way too much power to overrule the people's elected representatives, essentially making them a third house of parliament. So at the end of the day, here's the bottom line. Despite all the debate, the Basic Structure Doctrine has stood the test of time. It remains the ultimate constitutional safeguard in India, a powerful and truly unique Indian solution that was born from this historic clash of power.
And this brings us all the way back to that central tension, leaving us with a fundamental question that honestly, every single democracy has to grapple with. When it comes to the very soul of a nation, who should have the final say? The elected representatives of the people or the unelected guardians of the Constitution?